Should you have time to do the first one?
Sure. Will you tell me where they at?
I have all 7 of them back, one of them's in the back, so when they get done, I'll put them back there.
Yep.
Send them some of the
Yep.
others.
How's it going?
Yes, sir, all right.
Better not deserve. Raise your right hand. Swear affirmative the information contained in the affidavit is true to the best of your information knowledge and belief.
Yes, Your Honor. Squeeze this in.
No problem. This 49-year-old woman was playing hide and seek in the woods.
Sure.
Okay.
Okay. Or 140. Right. Yeah. I'm assuming. Starts tomorrow. Yeah. And he works tired all of a sudden. Yeah. Oh, it's because he has and he's not. Our things that we're going to go to toppers. Yeah. What do you have tomorrow? Tomorrow. Was it like a trial? Yeah. So, someone told me to think about, I never was like officially assigned to that docket. Is I already there? Yeah. Did it ship? Oh, you were already assigned to it for a minute? Was it Brad? It was never my little docket. Like there was enough APA under it. Oh, because you've been, see, I always just think like, just like as an AP. Attorney. Yeah, no, my brain goes.
You're welcome. Yeah. Too bad. I mean, 49 years old. She's worried about dementia. Yeah, I never heard that one before.
That's what's comical, but she wastes a lot of resources, so.
Yeah.
I gave her a lot of opportunity, she chose to stick with it.
Right. And it is a waste of
I
resources.
love exams.
We'll
I
see if
loved
you
it, and I
can
thought
get what we
we
need out of
were-
it.
Yeah, good luck.
We get along so well, like. I love like the standard. like, arcade, like. Did you go take blood notes or something?
Be safe. Be all
Take care,
set.
guys. Thank
I
you.
haven't either.
You got my cell kit? You got to follow up on anything?
Yes, sir.
You're about to.
Thank you.
Well, I just want to ask, what are we doing today? Yeah. Like, thank you. I will do that.
Hey, are you keeping the jurors out there until you bring them in the courtroom door, or how are you gonna do it?
No, he's taking them back to the room.
Okay.
Unless you want to bring them.
Nope, nope, that's fine. Tell the defense attorney to come on in then.
Okay.
Thanks.
Yeah. Have you had the drink? Yes, in the cover road? Yeah. Yeah. No,
Yeah, this didn't work today. Have a seat, have a seat. Okay, folks, time for final jury instructions, so I get to read to you. The evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you've taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. And it looks like you're all following along all right? Okay, so sorry, I usually walk you through where I'm at. Smarter than the average bear. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it's important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments and any commentary are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evident. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider these things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness' disability, gender, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. We're going to go back to evidence instructions at this point in that sub-menu. The prosecutor introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case. If you believe that a witness previously made a statement inconsistent with the testimony at this time, the only purpose for which that earlier statement can be considered by you is deciding whether the witness testified truthfully in court. The earlier statement is not evidence that what the statement said earlier is true. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough reason to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. She only has to show that the defendant actually committed the crime and that she meant to do so. Back to final instructions. Under page 4, elements of the crime. The defendant is charged with the crime of domestic assault. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant assaulted Lavelle Smith. A battery is the forceful, violent, or offensive touching of a person or something closely connected with him. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Lavelle Smith's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit a battery or to make Lavelle Smith reasonably fear an immediate battery. An assault cannot happen by accident. At the time of an assault, the defendant must have had the ability to commit a battery, or must have appeared to have the ability, or must have thought she had the ability. Second, that at the time, Lavelle Smith was a resident or former resident of the same household as the defendant, or was a person with whom the defendant had or previously had a dating relationship. A dating relationship means frequent, intimate association, primarily characterized by the expectation of affectional involvement. It does not include a casual relationship or an ordinary fraternization between two individuals in a business or social context. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about August 7, 2023, within Van Buren Township in the county of Wayne. When you go to the jury room, you will be provided with a written copy of the final jury instruction. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on the verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Bless you. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the court officer. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in this case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and the instructions on the tablet. If you want to look at any of the reference documents or exhibits that may have been admitted, ask for them. We only had actually 2 visual pieces of evidence that were admitted. We'll send those into jury room with you. When you go to the jury room, you will be given an electronic copy of the instructions you've just heard. As you discuss the case, you should think about all my instructions together as a law you are to follow. And we have prepared a verdict form listing possible verdicts. That paper will go into the jury deliberation room with you as well. Ladies, I think that's it. Are you satisfied with the instructions as given?
Yes, Your Honor. Yes, Your Honor.
Thank you. All right, folks. Normally at this stage in the game, you look around, there's 7 of you. At this stage in the game, I normally, by random lots, draw a seat number out of a box, and that person is excused as the 7th juror, the alternate juror. Both attorneys have agreed that we're going to go forward today with a 7-person jury, mainly because you were all paying attention, and I hate to have somebody sit all day with me and do their job and then fire them before they get to actually, do what they're here for. So I'm going to send all 7 of you back. Joe's going to have the jury deliberation form in both exhibits. Any questions or anything, knock on the door, give Joe a note. And once again, anything you don't want to take with you, leave it there and it'll be safe. All right, folks, we are in recess. I'm going where it's cooler. I'm sitting there because it's colder, you're sitting out there. 'Cause it's warm.
I should keep them in there for a minute, right?
Yeah, because we gotta bring everybody in. Joe's running around they've already come to him for,
Oh, good. We have final bodies.
yeah, we call it their phone agreement.
Yeah, for now. Probably more comfortable in there. 80 degrees out. What do we got tomorrow? A little mixed bag of stuff.
Yeah, we have Sumter docket.
What's it
Only
look
two
like?
people,
Only two defendants?
two defendants that we-
Oh, is it the ordinance one?
Yeah. 10 o'clock, we have a sentence that we do every week. And then at 2 o'clock, we have,
I got the juvenile one.
yeah.
What's that? As little as you?
Yeah.
Where's she going to a concert?
I think that's what she was doing.
Okay.
It gave.
Yeah.
Okay. And I'm like, is this an accurate, a clear and accurate
Yeah.
representation of what you look like?
Never heard of Long Spring.
Yes.
First move to admit.
Literally.
Yeah.
With the hair.
Yeah.
Wednesday night.
I haven't been at a concert in 20 years. Actually, maybe more than that.
I haven't been, well, we haven't been back, but, we usually go see that for. But this past one, I stayed for $100.
Oh.
And it's like, I can go to the same concert. I choose to go.
My neighbors, Debbie's a huge Stones, and they went to Scotland. They've traveled all over and they've spent some big money on tickets. She's like a member of the fan club, so she gets advanced. She can buy before anybody else, you know, not just her, but people, that kind of fan, whatever.
That's cool. It's like on our cruise ship, they have a, I can't think of the name.
Yeah.
Nightclub that they have.
Right.
And they like the Beatles, like,
Tribute.
like,
I never liked the Beatles.
It was just like last week,
Oh,
Wednesday.
I just like some of them, but.
Yeah, well, they said they're ready, so I'm assuming that, I'm assuming they've reached a decision. I'll wait for you to find.
Yeah, she's on her way.
Have a seat, folks. Miss West, did they make you jury foreperson? I saw your paper in your hand. Jury reached a decision?
Yes,
All right, would you please let us know?
we, the jury, find the defendant not guilty.
Thank you. Ms. Mandarich, would you like jury polled?
Yes, Your Honor.
All right. Mr. Vance, is that your decision? Is that your decision? Not guilty, your decision?
Yes.
All right. Ms. Arthur?
Yes.
Ms. Kowalski? Mr. Cantrell?
Yes.
Ms. West?
Yes.
Ms. Dillon?
Yes.
And Mr. Julian, is that your decision as well, sir? Thank you, folks. Do we have a cash bar?
No, we do not.
We do not. Goodbye.
Thank you, Your Honor.
Thank you. I'm going to send you back in the jury deliberation room. I'll be right back there and we'll get you out of here soon. Thank you, ladies.
Leave tablets,
Thank you, Judge.
notebooks here, Judge.
Yeah, leave your tablets, leave your notebooks. We'll clean up your mess. Yeah.
I just realized that
Well, kind of you did on the record.
on the record, but this is high investigation.
Oh, yeah, that's good.
She's in exams right now at 36, and she's gonna be taking on 36.
Beautiful. Good luck.
Thank you.
Good luck.
It was a pleasure.
How come she didn't let you do anything to it?
I needed to take notes, I was pretty busy.
Yeah.
Okay, all right. Well, we'll see you
Yeah,
next
I was
time.
hoping I'd have like, yeah, if I hadn't gotten stopped, so I'm like, oh,
Yeah, split up the witnesses. Next time.
Didn't have more than one, but thank you.
All right.
I'm gonna run it as jury judge and help mess with the jury. Okay, good. Did you hear the verdict? No. Oh, okay. Let's go with that.